me, and now let me introduce the keynote speaker. We're very pleased to have Sylvie Tabet today from the government of Canada. She's General Counsel of Canada's Trade Law Bureau with extensive experience negotiating international treaties, including Canada's Free Trade Agreement with China, Canada's Free Trade Agreement with the European Union. She also acted in various investor-state arbitration cases, including under NAFTA. And we are very delighted to have Sylvie with us today. When I was reading Sylvie's biography, I thought that there was a typo, because at the end of it, it said that Sylvia lives currently in Japan, in Tokyo. So I thought that's another level of working remotely. You can work for the government of Canada, but you can live in the capital of Japan. I hope, Sylvia, you can say a few words about that before you will move into your presentation. And we hope to have around 15 minutes at the end for the Q&A session. And feel free to ask your question earlier, and other people will be able to upvote questions which they particularly like. So if we will have more questions than we can handle, then we'll only pick questions which received the largest number of votes. Sylvia, very pleased to have you with us today. The floor is yours.
Thank you, Jarek, for the kind introduction, and thank you to Bikkel for having invited me to kick off this conference. It's a pleasure and a privilege to speak at this virtual conference today on the state's regulatory powers in international investment law. As a government's lawyer, you can imagine that this is a subject that I have been confronted with for over the last 20 years. In fact, in the late 1990s, Canada was faced with a number of NAFTA arbitrations. And as a junior counsel, having just joined the Trade Law Bureau, I was assigned to work on what was essentially Canada's first investment arbitration case, the SD Myers case. And that case concerned Canada's decision to ban the export of PCBs in furtherance of its Basel Convention commitments. So I headed to the Environment Department to explain to officials of the Government of Canada that we would have to defend against the investors' allegations of breach of NAFTA, and that we have to do this in front of an arbitral tribunal. Well, as you can imagine, I was not warmly received. The first reaction of regulatory agencies is often to challenge the basis for international investment tribunals to second-guess government's policy choices. In that case, the investor argued that the ban discriminated against it, and that it was unfair because it could no longer export waste to its facilities in the United States. The tribunal concluded that there was a national treatment violation. Even if Canada had a legitimate goal, it could have chosen different ways to encourage the development of a domestic PCB treatment industry. Well, why am I talking about this case that is now over 20 years old? I tell this story first to point out that the debate is not new. And over the following years after that case and a number of others, there were a lot of concerns in Canada about regulatory chill and NAFTA constraining Canada's policy space. And that debate amplified over time. But I also bring this up because, notwithstanding the SD Myers Tribunal's conclusion, the award is actually often cited for the finding that when interpreting and applying the minimum standard of treatment, that the tribunals do not have an open-ended mandate to second-guess government decision-making. So in effect, the SD Myers Award showed that deference to government policy choices was an imprecise concept, and that it didn't really provide a clear answer to how the right to regulate interacted with investment obligations. Which brings me to the subject, the topic of today's conference, the state's regulatory powers and its limits. The title presupposes that international investment law constrains the state's right to regulate. And I'm sure that this distinguished audience will readily agree. Now, in a general sense, of course, it's uncontroversial to say that, like international trade law, for example, international investment law imposes disciplines on states. And therefore, by entering investment agreements, states have exercised their sovereign right and agreed to some limitations to their regulatory powers. As Judge Schwebel put it at the 22nd ICA conference in his famous defense of bilateral investment treaties, he said, and I quote, "Do BITs invade the freedom of states to regulate? Do they constrain the policy space of states? BITs are treaties. The very purpose of treaties is to constrain the freedom of states." And he recalled the findings of the Permanent Court in the SS Wimbledon case, where the court declined to see in the conclusion of any treaty by which a state undertakes to perform or refrain from performing a particular act, an abandonment of its sovereignty. The court said, "No doubt, any convention creating an obligation of this kind places a restriction on the exercise of the sovereign rights of the state, in the sense that it requires them to be exercised in a certain way. But the right of entering into international engagements is an attribute of state sovereignty." Now, some commentators and arbitrators have suggested that ISDS does not, strictly speaking, prevent the state from regulating, in that it only allows an investor to claim for compensation for a violation of an investment obligation. In light of the amounts at issue in many of the ISDS cases, one can doubt the value of this argument. And probably for the context, in the context of the discussion today, it's of secondary importance. Fundamental question is, what are the limits to the state's regulatory powers that states have consented to in investment treaties and beyond which they are required to pay compensation? Now, looking back at the broad and vaguely drafted standards in the early BITs from the 60s to the 90s, one can wonder whether BIT drafters really turned their minds to the balancing of investment protections with the state's regulatory powers. The historical context in which investment protection standards and ISDS developed was very different from today's. The content of international investment agreements has been and continues to be shaped by the political, the economic, and the legal context in which they are negotiated. The standards of protection for aliens were developed against the backdrop of expropriation of concessions contracts over natural resources and the mixed claim commissions that were set up after the fact to arbitrate compensation arising from particular events. And the same can be said for the Exit Convention, which was designed to encourage private investment abroad by offering dispute settlement mechanism to address disputes that might arise in the course of the investment. By doing so, the convention sought to create a climate of mutual confidence and the promotion of investments in other states, with the resulting economic benefits for the states. But what we know is that today's investment claims are not what the drafters had in mind. And the history of the Exit Convention reveals that Aaron Broaches and the drafters of the convention anticipated that the main source of ISDS of ICSID arbitral jurisdiction would be investment agreements, like concession contracts, and not investment treaties. So when the initiative was first being considered by the executive directors, Broaches was asked when the convention would be used, and his response was that, and I quote, "One hardly ever likely to obtain was the situation in which a government, when accepting the convention or parallel therewith, made a general statement that it would submit to arbitration a defined class of disputes with all comers, The more likely situation, in his view, would be that an arbitration clause would be incorporated in an investment agreement, and that the scope of any possible arbitration would be clear. It would be limited to disputes arising out of contract. And in fact, in one of the legal experts' regional consultations, he noted that if the convention were limited to disputes arising out of investment agreements with governments, perhaps 95% of possible disputes would be covered. No doubt, the advanced consent in today's investment treaties to a broad scope of disputes has tested the limits between investment protection and states' rights to regulate in unanticipated ways. What we have witnessed in the last 20 years is an explosion of ISDS cases challenging a broad range of regulatory measures. From the Phillips Morris arbitration, challenging tobacco control measures, to sovereign debt arbitrations against Argentina, challenging certain monetary policies, to investor challenging financial bailouts by governments, or mining bans in environmental sensitive areas, or as we have seen in Canada, a moratorium on fracking. Of course, many of these disputes still arise in relation to capital-intensive long-term projects like infrastructure, mining, oil and gas. But more often than not, the disputes arise not from commercial disagreement, but from environmental measures or social unrest or economic crisis or changing economic situations. In other words, measures of general application that have very remote connection or no connection at all with the foreign investors, but have an effect on them. And so the nature of the claims and the fact that they are brought under treaties which incorporate broadly worded treaty standards have compounded the problem. According to UNCTAD, in his 2017 report, more than 90% of ISDS cases arise from pre-2000 treaties. The standards in most of these treaties are expressed with language very similar to what was in the treaties of amity from over 60 years ago. They give arbitral tribunals great interpretive freedom to interpret the treaty and international law. And it is only in the last 20 years or so that the language in investment treaties has begun to evolve. Investor claims and arbitral awards from 2000 on have hastened the pace of change. And the push for reform of the investment system has certainly considerably increased in the last 5 years. We're now witnessing efforts by states at adjusting the scope of investment treaties and rebalancing them. In parallel to this, there's a desire to tackle what has been dubbed the legitimacy crisis in investment arbitration. And while not all states agree on where the balance should be, it is clear from ISDS reform discussions at UNCITRAL and UNCTAD's call for reforms of investment treaties that most states share similar concerns about a better balance. Why the strong reaction? Well, the WTO, of course, has had to contend with balancing states' regulatory flexibility with disciplines that ensure non-discriminatory measures, non-arbitrary measures, including in dealing with things like GMOs or various SPS measures. And it has not given rise to the same level of concern. Several reasons have been advanced to explain this particular problem in investment arbitration, and I see two main ones. The first is the nature of ad hoc arbitration based on the commercial arbitration model, and often relying on commercial arbitrators, which appears ill-suited to adjudicating public policy issues. The second is what I referred to earlier, the broadly drafted treaty obligations that arbitrators are asked to apply in deciding investment disputes. As a result, some arbitrators, supported by a number of academics, have approached investment law as a system of international administrative law, allowing for a sort of judicial review of the state's regulatory actions. This approach can be contrasted to that of states who, by and large, have tended to view the treaty commitments as specific and limited obligations. The more recent treaties emphasize this as the correct conceptualization of investment law by containing more defined obligations. Now, another reason can explain the failure of the system to properly consider the state's regulatory powers. Arbitrators have interpreted investment treaties in light of a single objective, protecting investors and their investments, and have placed these objectives above other objectives. In my view, excessive weight on this objective and disregarding the context of state sovereignty and states' right to regulate in the public interest has resulted in many of the problems we see in the awards. So where does this leave us? Perhaps in order to answer that question, I can share some thoughts on Canada's experience here. As I mentioned at the start, Canada has been at the forefront of the investment arbitration. It has been a respondent in NAFTA arbitration for over 20 years and has defended over 25 claims. But Canada has also been the home state of Canadian investors who have been important users of the system. They have relied on investment treaties to seek the resolution of disputes in which they have alleged that the host state has abused their regulatory powers and targeted them in unfair ways. And so this perspective, both as a respondent and as the home state of investors who rely on treaty protections, has influenced Canada's approach in its investment treaties. Early on, Canada recognized the changing nature of investment arbitration beyond purely commercial disputes and championed transparency and amicus submissions in the investment arbitrations. Canada has also sought to balance the right to regulate in the public interest and Canada's investment protection through a combination of carefully tailored reservations, exceptions, scope limitations, in order to preserve the parties' ability to regulate in the public interest. And as well, more precise elaborations of the treaty standards and guidance on the interpretation of these standards. Now we can see this approach reflected in agreements like CETA and CPTPP, and to a certain extent in the USMCA, the new NAFTA, although that agreement does not provide for ISDS as between Canada and the US. So I will just pick up on some of these elements and these innovations in Canada's recent treaties. First, Canada has introduced stronger references to the right to regulate in the preamble of its agreements, more balance between investment protection and the encouragement of mutually beneficial investments on the one hand, and on the other, the state's other policy objectives such as public health, safety, the environment, corporate social responsibility, and sustainable development, to name a few. Arbitral tribunals, as I mentioned, have looked at these objectives of the treaty and have looked at the preamble in their analysis of the object and purpose of the treaty. And while the preamble, of course, provides context and explains the reasons for the treaties, it does not contain legally binding obligations. However, the greater emphasis on the preservation of the right to regulate should signal to tribunals the need for a more balanced approach in their treaty interpretation, one that doesn't simply equate the object of the treaty to investment promotion and protection. And in the CETA, in fact, the right to regulate is not merely in the preamble. You can also find it in the treaty text as a specific provision where it is affirmed. And it's also in the joint interpretive statement that accompanied the conclusion of the agreement and made it clear that the obligations ought to be interpreted in a way that preserves the right to regulate. Second, Canada's recent agreements include more precise standards accompanied by clarification of these standards. And let me just give you a few examples of that. In TPP, clarification to the national treatment and MFN obligation was introduced in the text to ensure that the analysis of whether treatment is accorded in like circumstances takes into account all relevant circumstances, including whether the relevant treatment distinguishes between investors or investments on the basis of legitimate public welfare objectives. So there's a reference in there to the right to regulate, essentially. And similarly, you can find clarifications on indirect expropriation that provide guidance to tribunals in distinguishing between legitimate regulatory measure, which do not require compensation, and indirect expropriation, which does. Now, we know that arbitral tribunals have struggled to establish the exact demarcation line between the two. So in Canada's recent treaties, it is provided that non-discriminatory regulatory action by a party that are designed and applying to protect legitimate public welfare objectives, such as public health, safety, and the environment, do not constitute indirect expropriation, except in rare circumstances. So this clearly excludes the sole effects doctrine to determine whether a regulatory measure amounts to an expropriation. Of course, the tribunal would still need to consider whether the regulatory measure was taken in good faith, but the fact that a regulatory measure will only in rare circumstance amount to an expropriation signals a high degree of deference to the state. And so this analysis is materially different from a simple proportionality analysis, which we have seen in some of the earlier arbitral decisions. Now, the impact of these clarifications has yet to be fully assessed, of course. But what we notice is that there are relatively few findings of indirect expropriation by regulatory measures in recent awards. Of concern is the fact that the FET standard is now being used instead to find a breach where the measure doesn't quite raise to the level of an expropriation. And some have dubbed it the expro-light standard. In fact, from the very narrow standard that was initially contemplated by reference to the minimum standard of treatment, it seems that the FET has become really the core concept in investment arbitration, and somewhat of a broad, amorphous, and quickly evolving standard like the Hydra of Lerna, whose heads regenerate as states attempt to cut it off. FET claims are made in almost all ISDS cases, and most awards against states include a finding of breach of FET. What we are seeing in the last 5 years is also an increased number of cases that allege a breach of FET based on changes to regulations, and this is, of course, very worrying. The claims are often tied with claims that the measures are not proportionate, or that they are contrary to an investor's legitimate expectations of a stable legal and business environment. Some tribunals have suggested that a fundamental change in the legal framework would give rise to a breach, but it is hard to know what this means in practice. Absent a specific representation or a regulatory stabilization agreement, investors should expect, of course, that regulations change. And this leaves us with really no predictable way of ascertaining what makes a regulatory change so fundamental that it requires compensation. Now, Canada's recent treaties reject this broad idea, broad conceptualization of FET. And in TPP and in the USMCA, the FET standard is firmly anchored in the minimum, around the minimum standard of treatment, with a clarification that a breach of an investor's legitimate expectation is insufficient to establish a breach of the standard. In CETA, the approach is slightly different, and the parties have instead adopted a closed list of elements that are part of the standard, such as manifest arbitrariness and the denial of justice. And in addition, there has, you can find a clarification that the fact that a party regulates, including through a modification of its laws, even if it negatively affects an investment or interferes with expectations, does not amount to a breach of the FET obligation. I would submit that these clarifications close the door to an analysis of the reasonableness of the measure or whether it is proportionate to the objective. Now, in addition to these clarifications of the substantive standard, Canada has also included general exceptions for measures to protect human life or health. And those exceptions can be found in some of its bilateral investment agreements, as well as in its FTAs. Now, are general exceptions necessary? I think, this can be debated, and really the answer is it depends. If properly interpreted investment obligations contain their own internal flexibilities and the reliance on general exceptions is not necessary. Canada, in fact, has addressed this very issue in its recent non-disputing state party submission in the Echo Oro v. Columbia case in the following terms, and I quote, "Legitimate regulatory actions will rarely need to be justified on the basis of general exceptions because they will not constitute breaches of the investment obligations in the first place. In this sense, the general exceptions are an additional tool or a final safety net to protect the state's exercise of regulatory powers in pursuit of the specific legitimate objectives identified in the exceptions. Simply put, the government's policy space is not limited to the general exceptions." Now, beyond Canada's approach, which I have just described, some states have undeniably gone much further and have rejected altogether ISDS or limited the scope of ISDS claims through broad carve-outs. For its part, Canada has made limited use of carve-outs and self-judging exceptions. One example of such a carve-out is in the tobacco carve-out of CPTPP, which allows the parties to refuse to arbitrate claims that challenge tobacco control measures. And recently, the risk of ISDS cases arising from the pandemic has given rise to calls for a convention providing for a blanket carve-out from investment treaties for government measures taken in response to the pandemic, or even a blanket exception for health measures. And of course, for cash-strapped governments, this is not without some appeal. But the carve-out approach also raises some questions. Why carve out certain regulatory measures but not others? Why health and not the environment? Will this lead to a carve-out for all regulatory measures? And doesn't this risk closing the door to legitimate claims? Now, on the other hand, one wonders to what extent governments can rely on deference with respect to the choice of measures taken for the protection of public health. In light of the existing awards, one can predict that the extent of deference may vary from tribunal to tribunal. And certainly cases brought under old BITs could very well lead to an analysis of proportionality and the availability of alternative measures. In contrast, cases under more carefully drafted treaties would be unlikely to succeed. I want to conclude my remarks by observing that the question of whether arbitral tribunals will properly balance the state's right to regulate and investment protection cannot be entirely dissociated from the specific standards in each treaty. But it also cannot be dissociated from who decides the case. And that's an important consideration. So the discussions in the UNCITRAL working group regarding reform of ISDS have revealed that a large number of states are uncomfortable with ad hoc arbitrator deciding cases challenging regulatory measures. And looking careful and uncomfortable with these arbitrators carefully examining the state's public policy choices. The concerns are in part about potential arbitrator bias, and in part they relate to the fact that commercial arbitrators who lack an understanding of government decision-making are often appointed to these tribunals. Now, interestingly, concerns about conflicts and double-hatting and efforts to promote the diversification of the pool of investment arbitrators have led to the appointment of more arbitrators from the commercial arbitration world. One can question whether these individuals are well positioned to strike the right balance. Some states have advanced the idea that a permanent investment tribunal would be a solution to address these concerns. And a range of other options are also being considered, including codes of conduct and specifying qualification for arbitrators. Ultimately, whether the right balance is struck with ISDS reforms and the approach taken in recent treaties will, of course, have to be tested. And that will be tested through investment claims, and we will have to await the investment awards before determining whether the right balance was found. Certainly, one thing is clear: investment treaties must adapt to reflect the type of claims that are being adjudicated and to reflect the evolution of investment law. The search for the proper balance between investment protections and the state's right to regulate can simply not be left to investment tribunals. Thank you.